afternoon, everyone. Good afternoon and welcome. It's wonderful to have you all here. I'm Wendy Perdue. I'm Dean at the University of Richmond School of Law here, and I'm delighted to welcome you to this celebration of Judge Robert J. Merhige Jr. I want to offer a special thanks to the students of the Law Review who organized this. They're out and about, and as you see them, you can extend your thanks to them as well. It was 50 years ago that Judge Merhige received his commission to the U.S. District Court for the Eastern District of Virginia after having been nominated by President Lyndon Johnson. We're particularly pleased to welcome members of Judge Merhige's family here this afternoon, including his son Mark and wife and children. We have a number of former clerks, and we're delighted to have you here. And I know we also have present with us Twiggy Mungford, who I understand was Judge Merhige's longtime assistant. We're delighted to be holding this event in the Judge Robert J. Merhige Jr. courtroom, which we dedicated to him 6 years ago. You'll find a brief biography of Judge Merhige in your program, which mentions just a few of the many decisions for which he is best remembered. In addition to his court rulings, Judge Merhige is often remembered for what came to be known as the Rocket Docket, a nickname that captures Judge Merhige's passion for efficiency and his sense that that was an important part of the delivery of justice. He was also known for his use of alternative dispute resolution and was a vocal advocate of settlement efforts. He once said, "I just try to get both parties to recognize the strong arguments the other side has. Even a pancake has two sides." Judge Merhige was, as former Governor Beliles called him, a giant in the law. He believed in law, and he believed in enforcing law's protections, even when that entailed great risk to himself and to his family. He was one of the courageous judges who, during the 1970s, in the face of blistering opposition from his community, this community, decided a series of desegregation cases. His dog was shot, his property burned, and he was under 24-hour protection. Here's what Judge Merhige said of his approach. "I didn't go looking for social causes to advocate from the bench. I opened my courtroom one day and asked, 'Is anybody here?' A lot of people answered back, 'We're here, Judge, and we want our constitutional rights.' So I did the only thing I could. I listened, and I tried to do the fair thing, the right thing." Judge Merhige died in 2005, but his legacy lives on. You'll hear about that legacy in today's program, and we're honored to be joined today by the Honorable Roger Gregory and the Honorable Ann Holton, both of whom will speak about the judge. We also have a distinguished panel of his former clerks who will share their reflections and memories. But first, we'd like to share a brief preview of a special documentary currently in production with the American Documentary Film Fund. Executive producer Al Calderaldo and director Bob Griffith have partnered to share Judge Merhige's story through a series of interviews with those who knew him best. Thank you to both Al and Bob for being here today, and I hope you enjoy this short preview of the documentary film, The Judge.
Hello and welcome. I'm Emily Blair, Editor-in-Chief of the University of Richmond Law Review. On behalf of the University of Richmond Law Review, thank you for coming today. I am honored to introduce our first speaker today, Judge Roger Gregory. Roger L. Gregory, Chief Judge of the United States Court of Appeals for the Fourth Circuit and a member of the Judicial Conference of the United States, formerly a partner in the law firm of Wild & Gregory, grew up in Petersburg, Virginia, and graduated from Virginia State College and the University of Michigan School of Law. He is the first African American to sit on the United States Court of Appeals for the Fourth Circuit. President William J. Clinton recess appointed him to the court on December 27, 2000, and President George W. Bush commissioned his lifetime appointment to the court in July 2001. Judge Gregory is the only person in the history of the United States to be appointed to a federal appellate court by two presidents of different political parties. Judge Gregory became Chief Judge on July 9, 2016. Judge Gregory's numerous awards include the National Conference of Christians and Jews Humanitarian Award, the National Bar Association's Gertrude E. Rush and Equal Justice Awards, the Thurgood Marshall Award of Excellence, and the University of Richmond School of Law's William Green Award for Professional Excellence. He holds honorary degrees from Virginia Union University, Virginia State University, Virginia Commonwealth University, Widener University, and St. Paul's College. Judge Gregory presently serves on the Board of Trustees of the University of Richmond and the John Marshall Foundation. Please join me in welcoming Judge Roger Gregory.
Thank you very much. I guess as a member of the Board of Trustees of Richmond, I should join the welcome as well. I went with the Dean. It's welcomed you to the university. And Dean Perdue, thank you so much for giving me the opportunity to speak about a legend. And I think Judge Merhige would love that the film is called The Judge. Because that's how it is, right? One word, Prince, Cher, Madonna, I mean, Beyonce. Stars do that, that's the way they roll. One word is sufficient to the judge. You know, I was looking at the film. You know, I thought the pressure would be all of these wonderful people of the academy and the bar and the bench and these wonderful guests and these bright students. It is daunting, but the worst thing is to follow the film. I'm like the person at the movies and the film broke and I have to stand up and talk while they fix it. I wanted to see more of that. Thank you so much. But when, Bob, you have one, and both you have a piece in there as a headline about my town, Petersburg, and Judge Merhige's ruling. And to look at that, those were my classmates sitting there the day that Judge Merhige came to Peabody, and that is classic Judge Merhige. Nothing was 30,000 feet for him. It was literally boots on the ground in terms of jurisprudence and living the law and justice. He was down there, and these little kids, and I was there. I was in the class where integration or desegregation came to Petersburg. And I must say, it reminds me of this story of a book by Michael Joyce called Moral Tales and Meditations. He talks about a man on the moon. On September 12, 1962, a brash young Bostonian said that before the end of the decade, we are going to land a man on the moon. He said that in 1962. In 1954, Brown came out, and then, you know, it was 1 year of, we had to wait a year to find out what the relief would be. And the relief came out to something like, in a phrase, all deliberate speed. Well, the young Bostonian president and the new frontier was correct. Man walked on the moon July 1969. But it wasn't until Alexander versus Holmes, a case out of Mississippi in 1969, October, that finally the Supreme Court said, all deliberate speed must end. We must do it now. My point, man walked on the moon before Brown was implemented in my hometown. And Judge Merhige saw to justice. Because for him, it was not a matter of putting your finger in the wind to test the climate and the direction of the wind. The cardinal points of justice are always the same. They are unwavering and they mean what they say. And he was not afraid to say that. So this little boy from Petersburg stands before you all these years later, never meeting the judge or personally knowing him as a kid in Petersburg, but he carved a path that I was able to walk in. And there were some wonderful people. You know what I really feel the saddest for? The people who didn't give Judge Marriage Order a chance. And those who went away and never joined us at Petersburg High, because Judge Marriage didn't have to worry about a 70-30 split as he did in Richmond. It was easy. When he came, it was easy. One high school. If you go to Petersburg High Schools, you go to one school. Peabody became the junior school. We merged, but in that class from Peabody, there were future two-star generals. One of my classmates from Peabody went on to go to Annapolis, and they're judges and all types of people of accomplishment. We had a chance to find common ground. And Judge Marriage understood that, not because he was on a crusade, as he said. He was not a social worker. He was not a social engineer, nor was he one to refix the constellation of the concerns of men and women. But he was a person who was dedicated to the law and justice. You know, you can go to law school, you can go to medical school and be a great physician, but know nothing about healing. You can go to the seminary and be a great theologian and know nothing about faith. And you can go to law school and be an expert, if you will, but know nothing about justice. Judge Marriage knew that justice was the core and the being and foundation of being a lawyer, and understood it so very well. 1969 was a banner year. 1967, I mean, was a banner year, because I say that was a pantheon of jurists. Judge Marriage, Justice Thurgood Marshall went on the Supreme Court in 1967 from the Second Circuit. Judge Damon Keith went on the court in Detroit, who also did cases, the Pontiac case and those cases that came about. Difficult cases, but jurists were there to stand the test of time. Now, Judge Marriage, in terms of my experience with him as a lawyer and a bar, he was a friend of the bar. This is the kind of person who went to the bench. Before he was the bench, he had the mettle already. In those days, black lawyers were not members of the Richmond Bar Association. But the Richmond Bar Association voted on endorsements for judicial candidates, and that was a quasi-political type determination. You weren't a member of the bar, but in those days, an endorsement from the Richmond Bar was a very strong indicator of who might be the next judge. So Judge Marriage and Mr. Oliver Hill together sat down and worked out a way to have fairness. And what they decided was this: on the days that the special vote for endorsements, Old Dominion bar members were allowed to be in the audience and had the same vote as any other member of a Richmond Bar Association member, so they could be a part of the process, because Judge Marriage knew that inclusion is the hallmark of fairness. So this is the tenor of the man who went to the bench. And he was, as they say, he was a lawyer par excellence. But I like what Judge Payne said, that sometimes Judge Marriage was very creative. He was very creative. I wasn't on the Fourth Circuit then when they disagreed with him. I just want to say for the record. But they didn't disagree with him often. I think they said he had like a less than, a 5% reversal rate. 95% is pretty awesome. But this is the kind of person Judge Marriage was. I love it. Batson. Now, most of the people law, I don't want to, if you're not, Batson versus Kentucky basis that you can't strike jurors on the basis of their color. Judge Marriage was not a judge who would sit on the sideline and wait for the Court of Appeals to decide. Real time, he would watch the prosecutors, he would see the environment. If he saw that coming to striking African Americans, he would have a sidebar and would say, counsel, are we going to have a problem here with this? Yeah, because he understood that a trial was where the fairness was, and understood that. So you know very well in his court, you better have a very objective and palpable reason for striking that juror, because he was not going to have it in his courtroom. And another hallmark I remember about Judge Marriage was he had a way of making everybody feel engaged. Oh, he was tough. He didn't allow playing around with the court and making the court some theater for your benefit. So you had to know the rules. But he had a way of fairness. We had a case where the defense lawyers, we all had clients who were inmates, most of whom had committed 1 or 2 murders. They were in prison for a tax fraud case. And basically they were submitting income tax returns from prison and getting refunds. How that happened, that's another story. I'm sorry, how that allegedly happened, that's another story. But anyway, one of those men who had been convicted of multiple murders, he decided to proceed pro se. We were all just terrified. Is he going to mess up? Judge Marriage treated him with such respect. You would think he was somebody at the bar. And he responded to that, and it was beautiful. I was saying, wow, he did a great job, the pro se. But he did it because he understood he was in a court, and Judge Marriage always liked the fair fight. It's a fight, but it's got to be fair, and he always insisted on that. As a matter of fact, he would always joke. He said, when it comes to time for the jury instructions, he said, I really could instruct this jury on my own, but I know you're going to submit instructions to me. But he really could, because he wouldn't pull any punches. As Judge Spencer said on the film, he saw the whole, as they say, the gestalt, the full pattern of what was going on. He understood how that worked and how it was there. But one of my favorite things in terms of Judge Marriage was the day we set criminal cases for trial. It was like a festive occasion, and you work your way down the rooms. There were about 3 different rooms before you got to the judge. So you start off early and you talk to this group of lawyers and you move to the next room, all getting closer to the judge. And I'm telling you, Judge Marriage loved it. It was grand theater. He would sit there, his book, and he would write the dates himself with his book. And he'd have his book there, and then he would regale you in these wonderful stories. And he told how the Rocket Docket worked. They sent him to Florida to try some cases, and a lawyer from Florida wanted a continuance. And well, Judge Marriage knew he wasn't sent there to stall the docket. It was get the docket done. So what he did was the lawyer wanted a continuance. So what Judge Marriage said he did was he put the phone down. He didn't put him on hold. He put the phone down so he could hear. So he yelled to one of his clerks. He said, "There's a lawyer on the phone from Florida, and he wants a continuance. Can you look up what the word continuance means for me?" When he got back on the phone, the lawyer said, "Yes, Your Honor, right here. We will be right there. I think we can work that day out." But that's the way he was. He was innovative in a most creative and fair way. And when he told us about, he loved the little guy. He really loved the little guy. I think he always had the heart for the little guy. And he said that once they were setting cases, they're trying to get a trial date, and all the big-time lawyers were saying, "No, I'm sorry, I have to be someplace else. That's a conflict." And there was one sort of country lawyer there. He had an empty book. He had no conflicts. So they went through all, and after about 15 minutes or so, and finally getting a date, the country lawyer said, "Excuse me, Judge Marriage, I have a conflict on that date. I have to be at The Hague." So you do what you can to come up with it. But Judge Marriage taught me so much about being a litigator and how important it is to stay focused, to stay honest to justice. And it meant a lot, because when you go into court, your client is already frightened, everything is going frizzy. But he gave him a calm, because everybody knew that he was not on one side or the other. He had only one client, and that was the law. And he advocated for justice. That was his only mission. And it made the difference. And this little boy from Petersburg, who in his junior year at Peabody, all of a sudden the next year he'd be going to Petersburg High. And it was a wonderful experience. We had one little hiccup in October, sort of a little mini mayhem, but it went away. And the rest of the year was wonderful. But if we walk long enough, if we stay honest and true to what we believe to be words of iron, but not only that, but words deeds of conduct of justice, and treating everyone fair and being able to call what it is. You know, sometimes as you get older, you don't see as far, but you see what is real. And Judge Marriage is certainly like the hiker who leaves the mountain. Sometimes when you're on the mountain, you use the mountain's craggy little cliffs to climb up, and you don't realize how strong and powerful and how enabling it is. But like the hiker, when the further you get away from the mountain, you see its full majesty. And Judge Marriage's majesty gleams on the horizon and will ever be. I will be ever grateful for the opportunity to try cases before him. I'm sorry I didn't get the opportunity as a jurist to be on the bench with him, but he beat me running there. He had retired, but of course Judge Marriage never retired. The law was him and he was the law. To the Marriage family, thank you so much for sharing your wonderful father, grandfather, loved one, his dear Shirley. I remember if there was anybody who could eclipse the law, it was Shirley. And thank God for him. And to the law students and those who will go on, legacies to come, remember that a great jurist passed here, but justice never passes. Thank you.
Our next speaker, Secretary Ann Halton, worked closely with Judge Marriage as his law clerk from 1983 to 1984. Secretary Holton has spent her career as an advocate of education, especially for lower-income children and families. She earned an A.B. from Princeton and a law degree from Harvard. She has worked as a legal aid lawyer, a juvenile and domestic relations district court judge, a child welfare reformer, and as Virginia's Secretary of Education. As Secretary of Education, she sought to increase the Commonwealth's investment in public education and to ensure equal access to education, especially in high-poverty communities. Secretary Holton currently serves on the Virginia Board of Education. She is a visiting professor at the Schar School of Public Policy and Management at the College of Education and Human Development and a visiting fellow at the Center for Education Policy and Evaluation at George Mason University. Please join me in welcoming Secretary Ann Holton.
Thank you, Emily. Wow, what a treat to be with you all. Wasn't Judge Gregory phenomenal? What an honor to hear from you, sir. And what an honor to be with the family, Dean Perdue, students, fellow clerks, all. Listening to Roger talk about your days as a student in Peabody. My first connection with Judge Marriage was during my days as a student in Richmond. My dad talked about it a little bit in the film when in 1970 we were students in the Richmond public schools going to the all-white, almost all-white suburban schools when that busing order came down, and that sent me on I like to think that it began me on my career of public service. Judge Marriage's order, and my dad was, all we did was comply with an order. We didn't, we weren't trying to, like Judge Marriage, we weren't looking for trouble. We just complied with an order. But as a family supporting that order, I went to Mosby Middle School, now Martin Luther King Middle School, where I got my first exposure to people from backgrounds different from mine, and where we found that we had so much more in common than we had different, and it was just a very, very special opportunity. I found also the opportunity to be part of something bigger than myself, and what an amazing treat that was for a 12-year-old, and for that I'm eternally grateful to the judge. That led me, when I had the opportunity many, many years later, to apply for his clerkship, to be very, very eager to do so, and then had the great, great honor to get to work for him in 1983 and 1984. So I thought I could talk about a lot of different things. I thought I could do 15 whole minutes of jokes, right? Without repeating nary a one, but my fellow clerks said, well, don't use up all of them. Well, the truth is I could do 15 minutes of jokes and they could still do another 45 minutes and not repeat. Okay, he was one of the funniest men, one of the wittiest men alive. One of my favorites was, and he would do them all deadpan. So, Gil, the court reporter you saw in the film, Gil's been up since before breakfast. When are you lawyers going to stop talking? And you'd get a little ways into, wait a minute, he's been up since before breakfast? You know, you would be well into the rest of the argument before you'd figure out that he'd pulled one over on you. But nope, I'm not going to do 15 minutes of jokes. I thought I would I'm actually going to talk about one case. But one case that I think pulls out several, 3 or 4 significant qualities of the judge that I thought it might be worth commenting on today. And that is a case that you saw mentioned in the film, the case of Waller et al. Versus Butkovich et al. And those et als were important. And that was the case that arose out of the Greensboro massacre. Now, you know, it's amazing in our world where so much happens that this was a very, very significant event, and I'm sure many of you, like me, were old enough to know about it at the time, but we're just so deluged with news that you may not remember the details. And it comes to mind recently in light of recent events here in our beloved Commonwealth. But in the fall of 1979, there was a group of communists, the Communist Workers' Party, who were doing some organizing among the textile workers in North Carolina, organized a protest. They got themselves engaged with the Klan and the Nazis there, and they organized a Death to the Klan march in October of 1979. Well, no surprise that when the Communist Workers' Party is organizing a protest in Greensboro, North Carolina, and the Klan and the Nazis both say, well, we're showing up too in big numbers, and both sides making violent statements in advance, a lot of violent rhetoric in advance of the march. No surprise that the tensions were running high. Well, lo and behold, chaos ensued. 5 people died, all on the others injured. All 5 who died were affiliated with the communists, either members of the party or affiliated with them, including a Dr. Waller, who was a doctor practicing, had been a professor at Duke, had left his practice there to organize among these brown lung victims that he was treating in the textile industry. And he was one of the folks who was killed in that shootout, literally a shootout between the Klan and the communists. 5 people died, many injured, allegations of mishandling by the police at all levels. Really what happened was there was very, very little police presence that day. Why there was little police presence was one of the subjects of the litigation, but the allegations were that the police at all levels had lots of advanced knowledge that there was going to be trouble and should have been there and should have done more to protect. So that was, legal disputes ensued. It turned out in the end, the facts showed that the Greensboro Police Department had an informant embedded with the Klansmen. The National Federal Bureau of Alcohol, Tobacco, and Firearms had an agent embedded with the Nazis, both of whom had some allegedly advanced knowledge and varying degrees of having passed that on. So that was 1979. Criminal charges ensued for various reasons. The Nazis and Nazi and Klans members who were charged were all acquitted on both state and federal criminal charges. Then a civil lawsuit was filed. Enter Judge Merhige. The lawsuit was filed in 1980. The civil lawsuit, criminal trials took up a lot of the time, but then the civil lawsuit languished. Nobody wanting to touch it with a 10-foot pole, as you can imagine, in North Carolina. At the time, the civil lawsuit, I think there were 97 defendants on the original version of complaint, ranging from the Greensboro, 20-some members of the Klan group and the Nazis. This is the et al. On the defense side. There were state police, FBI members, ATF members, the governor, local police, and on the plaintiff's side, there were the family members of the 5 deceased and umpty folks injured, et cetera, et cetera. So big, massive headache for some judge, political dangers, et cetera. So needless to say, the case languished for many years until Judge Marriage was asked to come down and manage the case. And I was his clerk during the first half of the case when he managed the initial motions to dismiss, and my successors the following year were there for the trial. So that's the background. It was an extraordinary thing to watch our judge walk into this buzzsaw of a mess and make justice happen. And it showed off 4 of his remarkable qualities. First, his courage. The local judiciary, all the federal judges throughout North Carolina and frankly throughout the Fourth Circuit, nobody wanted to handle this case for all kinds of reasons, but not the least of which was their physical fear. This was a case where, this was long before we have the kind of security that we do today. We did have Marshal Service protection. Greensboro was turned into, police snipers on the rooftops for the days of those hearings. But it was a scary, scary physical danger time. And this was, somebody who had gone through the kinds of things that he and the family had gone through not that long before, 10 years, slightly over 10 years before. Courage in the face of physical danger, he relished it. He didn't even feel it. He raced into the fire. He's one of those guys who would have raced into the fire on September 11th. He relished, it took courage to be willing to take on this big a project, this daunting project that others didn't want to touch for political reasons. He not only relished it, he almost enjoyed. He was a bit of a show-off. Wouldn't that be fair to say? And the notion of getting to go down to North Carolina where all these North Carolina judges were too chicken to take this thing on and show them up, and 97 defendants and umpty-ump plaintiffs, but courage just came so naturally to him. It was like water. You just didn't even know it was there. He didn't see fear. He didn't see fear. Number 2, he was a management whiz, and that was, I said that in the film. He relished the opportunities he had to manage big litigation. You all know that from his cases, the Westinghouse and Keepone and other. He was really known across the country as a manager of complex litigation. But this case was one where when we went down for that first hearing in that Greensboro courthouse, 97 defendants, lawyers, parties, press, public, managing. I remember working very hard. I'm a young, naive, wild, radically trying to do justice, and I would have kept every single party in for as long as possible because, oh my gosh, somebody must have done something bad here for these terrible results to have happened. Well, Judge Marriage's instinct was, well, let's see if we can't get this thing down to size, and let's figure out, on the motion dismiss level, who are the most meaningful defendants that really belong in this lawsuit? Who are the ones that are gonna get tossed at some point anyway? Can't we clear things out a little bit here? Yes, he had the law on his side, of course, but his practical management sense really was one of the remarkable things he contributed to that case. His work ethic. Again, those other judges all over would have just been horrified by the notion that this case had been languishing for many years, and now somebody needed to go down there and arm wrestle it fairly quickly. This was not it was not your typical Rocket Docket case, but it was not a case that was going to take years and years and years to try under Judge Marriage, and he never ever hesitated to roll up his sleeves and get work done. But the most remarkable quality that he taught me in that case, and really throughout the time I got to watch him on the bench, was his humanity. And part of his humanity, he saw the humanity in everyone. And he saw the fundamental part of justice, what he loved so much about the court and being part of it, was the notion that everybody is entitled to dignity and an opportunity to be heard. And that, there's a line in the standard jury instruction that he used, and we all use all those terms about the law is no respecter of persons. And I always just, you had to scratch your head, because the truth is the law is a respecter of all persons, not of anybody's title, but of all persons, and he embodied that. And I'll tell you that first hearing, we went down to hear argument on the motions to dismiss. 97 defendants, lawyers from the feds, lawyers from the state, lawyers for the local players, lawyers, the communists by this time were, they had some of the best civil rights lawyers in the country representing them, huge teams of lawyers. Guess who at that point was not represented? The Klansmen and the Nazi. There were 20-some, and I got to just tell you what they looked like by that time, 1983, fall of 1983. They'd been through all these criminal charges. I don't know what they looked like in 1979, but what they looked like in 1983, frankly, was ignorant country bumpkins in way over their head in this courthouse atmosphere, and they were the only ones in the room who had no lawyers. And so they're sitting out in the courtroom when we come in, and the marshals are all doing their security thing, and one of them stands up and says, "Judge, I can't hear you." And he says, "What's your name, sir?" "Mr. So-and-so." "Well, you come right on up here, sir. I want you to come sit up in the jury box right next to me, because I want you to hear every single word." And he has the gentleman come up, the marshal's now, and he kept turning to him. "Now, do you understand what's going on? Are you with me?" And the other Klansmen and Nazis too, who were, as I say, the other unrepresented parties, the parties for whom you had no. Maybe deserved no sympathy, maybe had not recognized the humanity in others, but they were going to come out of that courtroom knowing that this judge was going to treat them with dignity and was going to give them an opportunity to be heard, even if it meant raising their hand from the back of the room. When I was clerking for Judge Marriage, we used to have a lot of Title VII pro se complaints. It used to drive the defense bar crazy that Judge Marriage's theory on those cases, I think the law's changed a little bit on this now, but Judge Marriage's theory was those cases go to trial, period. I don't care if there's no facts, I don't care if there's no that, those cases are going to trial because those people need an opportunity to be heard. And he would, tell the defense bar, "Don't worry, I can understand the difference between, there's a lot of people were upset at having been fired. They didn't have a case in terms of discrimination based on one of the prohibited criteria, but they were aggrieved because they had been fired," and he was doing a little bit of social work there. He was giving them an opportunity to be heard. But like that, back in that courtroom in Greensboro, I will never forget him treating those folks who maybe hadn't treated others with dignity and hadn't necessarily given others the opportunity to be heard. He was going to listen to them and make them feel that this was not that this was justice. This was justice. So I took those lessons with me when I went to serve on the Juvenile and Domestic Relations Court here in Richmond many, many years later, right down the hill from Mosby Middle School, where I had gone to school those many years before. And juvenile court couldn't be more different from federal court in just about every possible way. I mean, it's the baby court. It's a rocket docket in a different way. We had cases set every 5 minutes. It's a high volume. My colleague, Judge Taylor, used to call it the McDonald's of the court system, 4 billion served. So it was a totally, totally different court in every possible way except this. It was a trial court. So we interacted with the public every single day. And those lessons of treating people, certainly the lessons of courage, the lessons of courtroom management, very, very crucial. Lessons of work ethic, absolutely. But most importantly, that lesson of humanity I took with me. And to the extent I ever did anything right on the bench as a juvenile court judge, it was because I learned the lesson from Judge Marriage that everybody is entitled to dignity, to be treated with dignity. Everybody in the courtroom is entitled to an opportunity to be heard, to have their story told, to be listened to. And that was sometimes complicated to manage that with the management requirements of the setting, but it was a crucial lesson, and I'll be eternally grateful to Judge Marriage for teaching it to me. I'm so excited to hear the panel. We'll have some fun. Thanks.
I'd like to thank you all for coming out today. My name is Stephen Scaife. I am the online editor of the University of Richmond Law Review, and it is my privilege to introduce to you all our next set of speakers, consisting of a set of former clerks of Judge Marriage who are here to talk about their experiences with the judge. To my far right is Gregor Golden. Mr. Golden is corporate counsel at Northrop Grumman Corporation. He clerked for Judge Marriage in 1996 to 1997. Sitting next to him is Mr. Jay Ritter. Mr. Ritter is currently a partner at Halton & Williams in the Richmond office. Mr. Ritter clerked for Judge Marriage in 1979 to 1980. Next we have Ms. Rita Ruby. Ms. Ruby is also a partner at Halton & Williams in the Richmond office, and she clerked for Judge Marriage in 1986 to 1987. And last we have Mr. Michael Smith. Mr. Smith is a partner at Christian & Barton here in Richmond, and Mr. Smith clerked for Judge Marriage in 1969 to 1970. Moderating our panel is Professor Mary Kelly Tate. Professor Tate is the founding director of the Institute for Actual Innocence based here at the University of Richmond, and Professor Tate clerked for Judge Marriage in 1991 to 1992. Please join me in welcoming our distinguished panel.
Thank you, Stephen, very much, and thank you, panelists, for being here. We'll jump right in. It's been hinted at by our keynote speakers, but this man was a vivid human being in his personality and his way of being in the world. So I'd ask any of you and all of you to please consider just commenting on some personal remembrances that you have of Judge Marriage, and that could be during your clerkships or when you practiced or at any other time. Do I have a taker? Ms. Rita Ruby.
So having nothing to do with the practice of law or but he was not the most patient man in the world in some respects. Mark, I know you're shocked, right? He was always impatient to get to court because he so loved what he did. I was the assigned clerk with him on a series of cases that he was hearing in West Virginia. First time out of town with him, Gil Hallis pulls me aside and says, one thing you've got to know, whatever time the judge tells you to be downstairs ready to go, you need to be there 15 minutes early, because if you're not, you're late. I tried to follow that, but after a few days, one day I was early, which meant I was late, and the judge was already in the Grand Wagoneer with Gil, pulled out of the parking space, in the parking lot at the hotel. I come running out, now I'm in for it. But there were two competing things for the judge. I know he was as irritated as could be at this, upstart law clerk who was late, and was impatient, but at the same time he was a gentleman. So he jumps out of the Wagoneer, runs around the other side to open the door for me, except he didn't put the car in park. So it starts taking off down the parking lot, and he goes running back around, hops his little body into the car, and manages to jolt the thing to a stop. So that was one of my personal remembrances.
Rita, I want to disagree, though, because prior to the Second World War, he was okay with waiting in lines. It was only after the war that he stopped waiting in lines, as he often told us as we were in line for a restaurant.
That's true. Did it get discussed in the Wagoneer the morning, or was it let go?
I think he knew I knew.
Yes. Okay. Mike, did I see?
As his son, Mark, who is sitting right down here, and for those of you who didn't know Judge Marriage, Mark looks like him and has the same personality that his father had. My remembrance is something that I'd like to pass on to some of the young law students here today. I think Judge Marriage would want me to pass this along to them. For you that want to try cases, if you ask him what one characteristic does a trial lawyer have to have, he would no doubt say to you, if you assume the young lawyer is willing to work hard, and if you assume they have a modicum of good sense, then the one thing a young trial lawyer has to be is resilient. You've got to be able to pick up a file and go into that courtroom and lose, and not lose your confidence. You got to pick up a file the next day and go back. The other thing that I remember about him was he taught me what judicial independence meant. You've heard terms already used today of courage, humility, humble. All of those are true. But he taught me what judicial independence means, which is so important to all of us here today and something we need to protect. And he did not talk about what he did. This message to me from him was through his actions. Judicial independence belongs to the public. It is the guarantee that nobody can hijack a judge's independence for their own. Nobody came under more stress in attempts to hijack his independence than Judge Merhige did in 1969, 1970, 1971. He was castigated. We law clerks had to go out and put a penny on his hood each morning when he parked his car, and had to go back and check it in the afternoon to make sure the penny was still there. He was threatened about Mark. It is true. They burned his house. It is true. They shot at his dog. He never once, though, gave up his independence. He always remained independent, judicial independence. He protected it not for himself, but for the public at large. And nobody has exemplified that ability to do that under more stress than he did. Nobody. That's what I remember.
Thank you, Mike. Jay?
Perfect. Perfectly said. The other thing, I don't know that this has been mentioned. As a law clerk, we had the experience, or we were welcomed into an extended family. And it wasn't just the judge and his family. Everybody in the clerk's office, the marshals, and all the prior law clerks and all the clerks that came after us. And I mean, it was an experience you can't duplicate it. It was unique. And another sense that I got was, in law school, we're taught to think about the rule of law and how important law is. But with the judge, over the course of a year, you really do get the sense of what the court is all about, and the importance of the court, and the importance of the independence of the judges. But just the dignity and the need for respect for the court. And, you have this value instilled upon you, and then years later you hear a presidential candidate say that a district judge can't give him a fair hearing because of where the judge's parents were born. I mean, what would the judge have thought about that? I mean, just would have blown his mind.
It's not repeatable here.
It's what?
It's not repeatable here. Exactly what he would have said.
Well, I had the great honor of clerking for Judge Merhige in the twilight of his career in 96 and 97. So here I was a young law student, called a few breaks here at Richmond, had the great opportunity to clerk for Judge Merhige, and I was joining this truly a legend of law, someone, a huge figure in Richmond and nationwide. And it was a little intimidating, to say the least. But boy, he made you feel like a peer from day one. You really were entering part of a family. And all the talk about how much he cared for people and the individuals, it was deeply sincere for Judge Marriage. And it would, sometimes it would consume him. We wanted him to refocus. We'd have to get through the docket. We have this, but there'd be something, somebody that's having a problem. My co-clerk is ill. Something is going on in someone's personal life, and that was his primary focus. And until we could get that resolved and get them taken care of and get them a hot toddy or something, he wasn't going to go back to the work at hand. And it was a very sincere concern.
Yes.
And it was, law school, you're away from your homes, you work hard, and I really did feel like I was joining an extended family.
Absolutely.
The judge.
He once brought me Brunswick stew in the 3000 block of Gray Street when I was sick, and in a shotgun apartment, and this small man tapping at the door, and I'm in the back not feeling well, and I'm thinking, who is that? And lo and behold, there's a federal judge at the door with Brunswick stew for me. He found time. No one since brought me Brunswick stew when I'm sick, so I look back fondly on that. And speaking of his height, his old joke, he would say when he practiced law, he was 6'4", but when the bench gave him some additional height. Thank you, panelists. Next, what about, and you've touched on this somewhat, perhaps, but in a more particularized way, we're all lawyers. He was a lawyer. How did your year with him affect your professional career? And how does it animate how you may deal with clients, or how you might problem solve, or any manner of issues? How has it shaped you as a lawyer? Anyone want to jump in?
Well, Mary Tate, I'll take a stab at that.
Okay, thank you, Mike.
I have one great sorrow, and that's that I was not able to get up to his level. And there was a lot he had to teach me that probably went over my head, because I was just too stupid to take it all in. But he taught me how to treat people. And let me give you a great example of this. In the early 70s, federal judges made $54,000 a year. And he loved young people. He really loved them. And I am so sorry that you young people here today that did not know him will not get to know him personally. You'll know him through the stories you hear, but I wish you could have met him. But Judge Marriage had his secretary, assistant, but at the time she came with him from the old law firm. Her name was Ms. Rankin. A lot of people remember him. I see Phil Morris back there with a big smile on his face, as well as Judge Gregory with a smile on his face. Everybody remembered Ms. Rankin. And so he called one afternoon to two young lawyers in town, one of whom was a graduate of this law school. I won't go any further with it than that. And he had Ms. Rankin say to the young lawyers, "There's a motion in XYZ case, and I want you to come down here and take care of it right away." The judge does. He wants you here at 3 o'clock this afternoon. And so both young lawyers, Ms. Rankin and the judge, said, "Yes, ma'am, we'll be there." So the judge walked in at 3 o'clock. Gil Hallis, court reporter who's here with us today, no doubt was taking the notes of the hearing. And one young lawyer stands up and starts his argument. And the judge says, I want you to hurry up. You're making a good point. I appreciate your argument. I'm enjoying listening to it, but I know you've got some other points. Won't you make them? And the young lawyer stopped and looked at the judge and said, "Judge, it's clear to me you don't understand what I'm saying." Now, that would not be a good thing to say to a judge at 3 or 3:30 in the afternoon, some of the judges I know. But not Judge Merritt. He got the same wry smile that he has in the picture that you have today in your folder. The same smile, like the same one he sat back. He said, okay, I'll let you go a little bit further, but we got to move this along. Lawyer started again. After about 5 minutes, the judge said, now, I've got your point. I got your point. You briefed it very well. I read the briefs before I came in here, and I got it, but I do want to hear that second point. Young lawyer said, Judge, they taught me in law school to always lead with your best punch. It's clear to me, you don't understand what I'm saying. Same wry smile. The judge leaned back, caught himself, leaned forward and said, you're right, son. He said, I'm just not smart enough to understand your point. I know you're way beyond me, and I apologize for that, but he said, for $54,000 a year, you don't get John Marshall. Now, that's what I can tell you. And young lawyers in Richmond, Virginia, right Judge Gregory, love Judge Merritt.
Yeah.
Love being with him and around him.
Thank you, Mike. Rita?
I wrote down points because sort of
Please?
lessons that were specific to the law, but
Learn-
really translate
To
broader
life.
to life lessons.
Great.
So the first was he really believed in the importance of our legal system, and he believed that we were involved in the most noble profession that existed. He would want all of us to continue to remember who are lawyers now. It's not just a business. It's a profession. We are here to serve the public good. And I hear his voice echoing on that point. You know, every society people have disagreements. And some people feel they've been wronged. And they need to have a place to peacefully bring that dispute. There are other ways to solve it that are not as productive. So he believed in the system. Second, I think I saw in him every day, and try to remember this, that every act or omission every day goes beyond the particular case that we're involved in or transaction we're involved in. It has a larger effect. It either can contribute to public confidence in our legal system or it can detract from it. And that's a larger life lesson, not just about a legal system, right? We have an impact beyond that moment in time, all the time. And then the third is the point that, I can't help but call you Annie because that's what the judge called you, and said it. He loved you so much. It was clear to all of us. But everybody fundamentally wants to be heard and needs to be heard. We all have a story to tell. We all need to, and you saw that with him day in and day out in the courtroom. You saw it with him when you were having a meal with him at a restaurant. And I try to remember that in terms of not, whether it's with clients or witnesses or other parties, but also children and spouse and, friends and people I see standing on the street. We all just want to be heard fundamentally, and it makes a difference.
Yeah. Thank you. Gentlemen?
Well, I wonder, did you assign our seats? The trial lawyers are on this
Yeah,
side.
right.
The business lawyers are on this side.
There you go. Okay. I was not involved in seat
My
assignment.
cross-examination skills are much better by virtue of my clerkship.
But your consistent use of the serial comma is has been,
That's right.
Well, you did executive compensation. You didn't negotiate as 54,000.
No, I didn't. I would say the things that I took away that I used in my practice are, number one, how to try and treat people the way the judge did. We've mentioned the pro se litigant. It was not just the pro se litigant, but it was also if you had a defendant or a plaintiff who was not sophisticated. It's not a corporation. It's, an individual who doesn't really know the court system or the legal system. And the other thing that I learned quickly was at 25 or 26, just how naive I was. I mean, I didn't know anything about human nature. There was an arraignment one day. The defendant had been a hospital administrator here in Richmond, had moved on to another job in Dover, Delaware, and had been indicted here for Medicare fraud. And so there was the day of his arraignment, and we opened court at 2:30, no defendant. His lawyer said, well, he was driving down from Dover, give him a little slack. So we recessed, we went back at 3, we went back at 3:30. 3:30, the judge says, marshals, go get him. I'm going to issue a bench warrant. We go back into chambers, and I said, Judge, do you think he's skipped the country? And the judge said, no, I think he's dead. And I'm like, 25 years old, I'm thinking, no. I get home, and we turn on the news, and the guy had pulled off the side of 301 and shot himself. Just never would have occurred to me that that's what was going to happen. But he knew people. He could read people so well.
It's mostly the life lessons that live large mean and how you interact with other people. You are young, you come into that clerkship, you don't know much about anything. I'd only worked a few years on Capitol Hill, not much professional experience, and learned a lot just watching Judge interact with the best lawyers in town and the unrepresented in town, and everybody got the same treatment. I can offer a practical point. You spend a lot of time here in law school taking simple things and making them very complicated. I think Wade Berryhill, 2 hours on loss versus mislaid. You thought you knew what that meant, but you could really break it down. But Judge Marriage, what I loved about him is he took the very complex and made it very simple.
Absolutely.
And taught you how to think about the law in that way. He was always looking over the horizon. He knew where the case was going. He wasn't pre-deciding it, but he had seen a lot of it, if not all of it, before. And so when you were faced with this daunting antitrust case or something particularly complicated that I had no exposure to, he knew that he taught me that the law is a reflection of our societal values, and if you approach it in that way, you will have a pretty good sense of where that case should come out, and that'll help you wade through all the complexities and get to the right result, and it allowed me to be a better clerk.
Absolutely. Judge Marriage was nominated and confirmed in such a condensed period of time, a month or two, and the data that I have is over the Obama administration that district court judges from nomination to confirmation were taking 225 days. All federal judges were taking 231 days, and circuit court judges were taking 261 days. So this man who we've all described and seen a temperamental thread of perhaps not having tremendous patience, except patience about people's personal dignity, but not patience about inefficiency or clogged courts or those kinds of things. Does anyone want to venture a postulation about what he might think of today's confirmation quagmire? And this may be too speculative, but what he might think has caused that, or what the cure might be, or what any commentary?
The judge loved to talk politics. The year I clerked for him, it was election cycle with President Clinton running against Senator Dole. I had spent a brief period of time in Capitol Hill working for John Warner and Arlen Specter, so I was a Republican. He loved to talk politics with me, and both of those senators had been on the Judiciary Committee, and my first day on the Hill, I admit, Judge Thomas, when he was beginning his rounds and had lived through the Thomas confirmation hearings. So we did talk a bit about it, and he loved to talk about the election. Of course, we all knew where that election was going, so it was fun for the judge to talk about that election. But he often stressed that, his oath was to the law. It wasn't to the person who appointed him. And my sense is that the judge would just want the vacancies filled, whether they're a Bush appointee, an Obama appointee, or a Trump appointee. Let's just get the job done, because once you're wearing the robes, the vast majority of those cases are decided the same way. And our judiciary is the pride of our democracy, and the judges take their role seriously, and the politics really don't matter at the courthouse. So I think the judge would be frustrated by the amount of rancor in our confirmation process.
Anyone else? Okay, we'll move on. So it's widely understood and reported that during the Carter administration, Judge Merhige, who would have been deeply into his career at the federal district level, was communicated with, or there had been talk about him being appointed to possibly the District Court of Appeals, and that he showed a very strong and unbending commitment to staying a federal district judge. So I'm curious if anybody might want to talk about why Judge Merhige might not have wanted to move up the judicial ladder, so to speak. And did that have to do with temperament? Did it have to do with, the fact that he was a trial lawyer? Did it have to do with the fact that he had a strongly executive personality, to go back to Ann Holton's reference about his management style, and that the appellate process is a more collaborative undertaking? But anyone want to comment on his commitment to...
I don't think he would have been happy on the Court of Appeals. I mean, the law's the law. He would love that. I think the thing that he would miss the most are the lawyers.
Yeah.
I agree with that 100%.
Present company, except...
There was also a lot of conversation about Judge Merhige being appointed to the number 2 post in the Department of Justice. But what he really liked were the lawyers, and he would not have enjoyed, I don't think, and I think he knew it better than I, any more clandestine than the district court was. At least the lawyers were coming in. Judge Gregory told you about how they ran the setting the cases, and lawyers were always buzzing around there, people were buzzing around there, and he was buzzing around there. And he thoroughly enjoyed that. And I don't believe, I think Jay is exactly right about that. I think by personality, he was too much of a people's person to swap that courtroom he had in Richmond that he loved dearly, and his lawyer friends that came over to see him by necessity or choice, both. He would not have swapped that for a more clandestine situation in a court of appeals. I think that's exactly right.
I would just add, I don't think not even just the lawyers, but all of the people, all of the personalities, the witnesses, the parties, the stories that they came out with, that kind of give and take experience. I mean, we all know as clerks, right? He was such a people person. He had a lovely office in Chambers, but he didn't like sitting in that office, right? He wanted to be sitting out with the clerks. He wanted to see the clerk's office people coming in. He wanted to see Gil coming in.
Yes.
I think he would have missed all of that.
Yes.
Mary Kelly, another anecdotal story that you, Mary Kelly, take.
I like Kelly. Kelly's just...
Mary Kelly, when I first knew her. But another anecdotal story about the judge and his relationship with people. His best friend, a generation older, was a lawyer that graduated from this law school when he graduated too young to take the bar. He was a criminal lawyer by the name of Leif Bremner. And Mr. Bremner, because of his relationship with the judge, was asked to speak for the Richmond bar on the day that the judge was sworn in. And Mr. Bremner stood up, cleared his throat, and said, Judge Merhige, I have a motion to make today, and I make it on behalf of the entire bar of the city of Richmond. We move that you continue these proceedings indefinitely. In other words, don't get sworn in. Come on back to us. That's what it was all about.
Right, absolutely.
We should clarify that the judge did have a deep respect for the Fourth Circuit Court of Appeals. He often reminded me
Right, thank you, Greg.
that they
Thank
were
you very,
several
very much.
$1,000s a year smarter than he was. He always made that point.
Thank you for that good work.
But he also said that if there's Supreme Court or Fourth Circuit precedent, you have to follow it. Otherwise, do your best and don't worry about it, because there's always the Fourth Circuit.
And he loved the findings of fact. He liked making findings of fact. So, okay, I'd be curious, just a larger question. Do we think that people who aren't lawyers, people who didn't work in the clerk's office, people who didn't have the experience of being a juror in his room, in his courtroom, that the public really understands the role of the federal district judge? And he was such a powerful figure. What might it mean for this documentary, or for just those of us who've known him and want to keep alive his impact? The fact that the public may not have a deep understanding of what a federal district judge does, and how his life was at the center of the American experience. I suppose it was headlines, but any comments on that, or how he might have been atypical?
I think people do not, in society broadly, have an understanding, and it's why I really do think, and it's not that he said this, you just saw it, that I think that's why he viewed it as so important, that when people did have an interaction with the system, that it'd be a positive one. So that they would leave that courtroom experience feeling better about our legal system than the way they felt when they walked in.
Right.
Because he wasn't concerned about the way people thought about him, but he had a huge interest and concern about how people perceive the court.
Absolutely. Yep. Absolutely. Any closing? We are 2 or 3 minutes from the close of this panel. Would anyone like to have some?
I don't want to take up the 2 or 3, but I would be remiss if I didn't tell you one more story. And I would be remiss because I'm sitting at the University of Richmond that he loved dearly. There's his picture up there. And the story goes this way. He was Lebanese. He was born and raised on Long Island in New York. Now, not at the Hamptons, by the way, far from it. But that's where he was raised, and he came south and he went to High Point College in North Carolina, where he played basketball. And when he got through, he knew he didn't want to go all the way back to Long Island, but he wanted to go a little bit north. And so he asked a professor, you know, what do you think I might do? Professor said, you ought to be a lawyer, boy. And he said, I don't know anything about law schools. He said, well, you're going north. There's one in Richmond. There's a very good law school in the city of Richmond. You got to go right through there. The name of it is William and Mary. So Judge Merhige came in here, and with that smile.
We're out of time.
That smile of his and that personality, he barged right into Dean's office and he said, Dean, My name is Robert Marriage, and I am so delighted to be here. A professor, fine, outstanding professor at High Point College recommended your law school to me, and he said, I am just thrilled to be here. It is the #1 law school around, and I want to go here. My heart is set on it. Dean said, that's fine, son. When do you want to start? He said, well, when does William and Mary open classes? Dean said, son, you're not at William and Mary. William and Mary is 45 miles down the road. Why don't you go down there and talk to the dean? He said, Dean, let me start again. He said, I had to hitchhike up here, and it wasn't easy. I don't want to try going east. He said, let me tell you what I think. You know, I have been here, and I already know that I love the University of Richmond. The dean let him in. He then went and stayed in the garage of Herndon Jeffries, a lawyer who had been here for many years, and stayed with Herndon Jeffries and his family in a room over the garage, and went to St. Christopher's School and coached to make money to go to law school some of the athletic teams. And that's another piece of the Judge Marriage story. You now know he thought he was going to William and Mary, that very fine law school.
Perfect. Rita.
I was just going to say, I shouldn't after that was such a good story, but more serious. I think he would be worried about a lot of things that he sees right now and some mistakes that seem to be being repeated that you would have thought we would have gotten past decades ago. But at the same time, he would have been hopeful because he knew he lived in the greatest country in the world and that we have the greatest legal system in the world, and he had faith in all of that, and I think he'd give us hope.
Gentlemen?
I don't think we can top that.
On that note, I want to thank the keynote speakers, Law Review, the panelists, Emily Cherry, Mary Ruth Walters, Dean Perdue. Thank you. Family, the Marriage family, and there are refreshments and a celebration outside. Thank you very much.